Good morning. Before I call my next case, I want to welcome Rachel First and Girl Scout Troop 525 who are joining us in the courtroom today. Welcome. We applaud you for your pursuing further civic education. Two of our court members actually either have been or were members of the Girl Scouts. Justice Riggs was a Girl Scout as she was growing up. Justice Behringer was and is a Girl Scout. This is her 56th year as a Girl Scout. She started when she was 2. She got the highest award as a Girl Scout, and she also got the national award because of her different leadership roles as well as her continued commitment to the Girl Scouts. And I can speak for all the court that we love the cookies. Our next case is Durham Green Flea Market versus the City of Durham, and we will hear from the appellant.
Mr. Chief Justice, and may it please the court, Troy Shelton on behalf of the Durham Green Flea Market. With me today as co-counsel is Robert Perry, and I'd like to reserve 5 minutes for rebuttal. The question in this case is what level of specificity must be provided to a property owner in a notice of violation? Due process, statutory law, and an ordinance all set a floor on that level of specificity, but Durham's notice fell below that floor. The notice didn't describe the violation at all. The notice referred the market to the site plan, but the site plan has so much detail that the violation could be anything. The notice said, "See attached," referencing 4 photographs, but those photographs are far from self-explanatory. To be sufficient, a notice of violation must be specific enough that an owner can prepare a defense or cure the violation. But the circumstances of this case showed that the notice lacked that level of specificity. The market didn't understand the violation, and neither did the Board of Adjustment. And that is no accident. It was by design. The city staff admitted that the notice was intentionally vague. The staff didn't want to follow the law because they didn't want the market to be able to cure the violations. This case presents a straightforward violation of due process. The judgment below should be reversed, and this case should be dismissed. If the city believes that violations remain, then they can start afresh by issuing a new notice of violation. The level of specificity required for notice of violation is controlled in this case by 3 bodies of law: constitutional law, the federal due process clause, and the state law of the land clause, the notice of violation statute, and Durham's own notice of violation ordinance. To understand how those laws apply, I think it's helpful to keep in mind what the purpose of a notice of violation is. The purpose of a notice of violation is to enforce the zoning laws by bringing property conditions into compliance with the law. The goal isn't to punish the landowners, but to coerce compliance with the law. The process begins with a notice so that hopefully a dispute could be avoided altogether. The notice is supposed to tell the landowner what's wrong and how he can fix it. To accomplish that task, the government should want the notice to be specifically clear. These purposes help to understand the amount of specificity that should go into the notice of violation. On top of that, the due process clause and the law of the land clause set the floor on how much detail need to be provided. The amount of detail required for due process must be enough so that the landowner can decide, is he going to cure the violations or is he going to go to court and defend them? And should he decide to contest the allegations, there has to be enough detail that he can first prepare a defense, because he has to prepare his witnesses, his exhibits, and whatever other evidence he's going to bring with him to the hearing, and determine what legal arguments he's going to make at that hearing. As to the standard, I'm not sure how far apart the parties are. Durham hasn't really proposed any alternative standard. Durham doesn't appear to criticize our standard, and it hasn't cited or argued really any contrary law. Instead, Durham has 2 arguments, arguing that it complied with our standard for 2 reasons. The first is that Durham argued in all the prior proceedings in this case that the written notice was sufficient merely because it said the property didn't comply with the site plan. Durham's position is, or at least it was, that just saying lack of compliance with the site plan satisfies due process, but that can't possibly be enough.
And let me stop you there. I got at least the impression that there was also an argument that because there was a telephone offer, you could call up and clarify. Does that in any way cure the fact that from your position, the written notice was not sufficient?
No, that doesn't cure it. So the Court of Appeals looked at that as a second opportunity to be heard, but this case is about whether there's advance notice. So the notice can't be delivered informally. First of all, the statute and the ordinance both require specificity in the notice itself. So if you have to go and contact the city, then the notice has violated the statute and violated the ordinance. Uh, that also flips the burden on the landowner to come get the notice. That's not what due process requires. Due process says, no, you government are the ones. If you want to impose sanctions or anything like that, then you are the one that's responsible for giving the notice and the front end. Because if it's the citizen's burden to come get the notice, then there really is no notice requirement, because that could always be the case, that the government could say, I'm going to give you some very vague notice. Come to court. There's going to be a trial. I'm not going to tell you what it's going to be about. Let me know if you have any questions. And that would never satisfy due process. To go back to the site plan, which seems to be Durham's one of their main positions, or it was, in a case like this, saying, well, the site plan has been violated, that's like indicting someone for tax crimes, but not saying, well, I'm not going to tell you which tax crime you've actually violated or what conduct you've committed that violates the statute. And as this court has seen from the record in the briefs, the site plan is a complicated set of drawings with tons of detail. Site plan captures lots of things. It captures buildings and structures, setbacks, utility lines, parking and roads, traffic access points, and stormwater control. So there is no way for a landowner or a neutral adjudicator to understand what the conditions on the property are that are out of compliance with the site plan based on something as generic as that. And that's borne out by the record in this case. Neither the market nor the board nor the Superior Court could understand what the actual violations were. Just like in Chastain, the recent case from this court, where the charging affidavit had to set out grounds for the removal of the clerk, here the notice of violations got to set out the specific grounds for the violation of the site plan. The case is also like O'Brien, where this court reversed a contempt order. Just like with civil contempt, a notice of violation is seeking to compel a landowner to comply with zoning laws. So the alleged conduct has to be stated with particularity in the notice so that the party can come and defend. And then the purge or the cure condition, just like in civil contempt, also has to be stated with particularity so that a party can know how to comply to avoid sanctions.
I just want to ask a question about the record. Reading the transcript of the hearing below it appears that there had been previous notices of violation, and that in response there had been submissions of new site plans, and that kind of course of dealing had happened for quite some time over the life of this flea market existing here. And I guess my question is, if they are in the record and I missed them, I apologize, but were the prior notices of violations more specific, or was this a repeat of notices that just said you're not complying with the site plan?
Unfortunately, they're not in the record, Your Honor, so I can't answer the question for you. So I simply don't know what the level of specificity was of the prior notices.
But it is correct that there had been this back and forth over time with multiple resubmissions of new site plans.
I know that the transcript reflects that there have been prior notices of violation. There have been new site plan submissions. I think the site plans actually expire after a certain number of years, so those have to sort of be re-upped anyways. So I think it's hard to reconstruct what the history was based on this record. But my point is that each notice of violation has to comply with due process, the ordinance, and the statute. And this one doesn't comply with any of those standards, Your Honor.
So if we agree with you that the notice, for example, didn't comply with Durham's ordinance, do we need to reach the due process issue, or do we need to look at the due process case law to interpret the ordinance?
If you agree with us on the ordinance, you don't have to reach the statute, or you don't have to reach due process. If you think there's some ambiguity in the ordinance, you might use due process to fill in the gaps. You might use the canon of interpreting the ordinance, like in the school dev case, in favor of landowners. You might use those as tools to fill in exactly what level of specificity if you need to. But if you think that the ordinance itself is sufficiently clear, then you can reverse just on that reason alone. Durham's other argument is about the photographs. So it's now arguing that even if the written words were insufficient, the 4 attached photographs were sufficient. There are a lot of problems with this theory, besides being argued essentially in this court for the first time. I think that the court can look at the photographs as we set them out in our reply brief, copied straight from the record, and understand that these photographs are far from self-explanatory. The city, of course, tries to explain the photographs in its brief, but those explanations weren't accompanied in the notice of violation, and written words are what's required for the notice of violation. And of course, the photos didn't make anything clear for the Board of Adjustment. Even the board members who voted against us, they were asking the city to clarify what were the violations. They had the notice of violation and the photographs sitting in front of them, but they couldn't understand the violations from the record before them. The city is also insinuating, in this case, that there was actual notice here, which would relieve it of its burden to follow the law. The argument has both legal and factual problems. On the facts, the board did not find as a fact that there was actual notice. That's a finding of fact that my friend on the other side would rather add to the record. Instead, Mr. Perry testified credibly that the market didn't understand the violation. And of course, he could try to guess, but as this court held in Griffin versus Griffin, just because you show up at the hearing and you do your best in the face of a due process violation, that doesn't cure the violation. On the law, actual notice isn't relevant. The statute requires written notice, and that has to be strictly enforced. That was the teaching of this court in the Carolina Plywood case. And as Justice Dietz explained in his concurrence in Duvall case from the Court of Appeals, once a due process violation is shown, it's the government's burden to prove that the error was harmless beyond a reasonable doubt. The city has never attempted to meet that standard, and I think that even staying here today, what the violations are very unclear. I do want to be clear that I don't think that this case is just about mere formalities. It is apparent that the city gave intentionally vague notice because it didn't want the market to cure the violations that they claimed existed. And I think that that should be concerning. If the government doesn't have to give notice of its accusations, then it can make up those accusations as it goes along. That's exactly what the dissenting opinion pointed out at the Court of Appeals. The notices could be used to harass landowners and businesses. It could be the city doesn't like the property owner's race. It could be the city doesn't like a particular kind of business, even if it's completely illegal. It could be anything unrelated to the condition of the property, but due process is an important check on that kind of irrational government action. What the city did in this case is illegal, it's bad policy, and it's also a complete outlier. As one of the board members noted at the Board of Adjustment hearing, he had been sitting on that Board of Adjustment for a long time. He had never seen a notice of violation like this. But if this court approves this notice of violation, that's what landowners are going to see in the future. Cities aren't going to have the incentive to do the right thing. The notices aren't going to describe the violation. They're just going to say, see the site plan. And businesses and landowners, they're going to lose whenever they appeal because they're not going to have a fair chance to meet those allegations in court. I believe that'd be a horrible outcome for our state. And like I said at the beginning, I think that the application of due process in this particular case is straightforward. We agree with the dissenting opinion at the Court of Appeals. We think that this court could easily adopt that opinion as its own and reverse on those grounds. And if there are no other questions, I'll save the rest of my time for rebuttal.
Thank you, counsel. We'll hear from the appellee.
May it please the court. Good morning. I'm John Roseborough. Seated at the table is Sarah Law. We are from the Durham City Attorney's Office. I will present the argument for the city today. This case is not about the city telling the flea market that it cannot use its land to run its business. Instead, this case is about the city doing its duty to make sure that the land is used in a way that promotes the public health, safety, and general welfare. The flea market is free to use its land to run its business in a way that matches its existing approved site plan. Alternatively, if the flea market wants to make a different use of its land, it can do that so long as it lets the city know what it is doing by documenting that different use with an updated site plan. The flea market did not do either of those things in this case, and so the city issued a notice of violation. The Court of Appeals majority opinion correctly ruled that the notice of violation satisfied the requirements of constitutional due process and the city's zoning ordinance.
So we have held for a very long time that the ordinances that are at issue here are in derogation of the common law. So the sort of default understanding in our state is that people have a common law right that's incorporated into the law of the land clause to do whatever they want on their own property. And so, you know, for your client to come in and say, actually, we're going to restrict that, as you said, in the interest of public, one of the obligations that we have imposed as the courts is you have to be very, very clear. And if there's any confusion, any ambiguity, what you say, you lose. We're going to construe that in favor of the free use of the property. And what I understand the argument your friend is making here is that if you read, you know, the ordinances, it seems pretty clear that the ordinances are anticipating when it says we'll give you a description of the violation, and then the ordinances chose to define what a violation is, describe it out. So we're not using ordinary meaning there. We're saying what is a violation, and it lists those things. It says it's, you know, the creation, establishment, and so on of, and then it says the, you know, use, an activity, a structure. So you take that and you look at the notice of violation here and say, where are the descriptions of the use or activity or structure that's in violation of the ordinance? You don't see it, because I think you're conceding the argument was, we'll just look at the site plan. And so my question is, if there's some ambiguity there, we can't even be sure what it means. Doesn't that just mean you lose under our case law?
If there is an ambiguity, you construe it in favor of the free use of land. I disagree there's an ambiguity with the notice of violation.
But we just heard your friend make a lengthy argument about his understanding that seemed reasonable. So your position may be reasonable as well, but doesn't that mean at best there's two reasonable interpretations of the language of what needs to be in a notice of violation?
Perhaps I should explain why I believe the notice of violation was sufficient. Because there are many parts to the notice of violation in this case. There's the written part, the letter from the compliance officer to the flea market. And what does that letter let us know? It let us know what the violation is. It is a failure to comply with an approved site plan. That written notice also explains to cure that violation, you need to remove all alterations, changes that are inconsistent with the site plan. So those words, that language lets the flea market know the problem is you're doing something out there that is inconsistent with your approved site plan. The problem is the alterations and the changes. So they have notice of what the problem is. But there's more. In addition to those words, there are photographs. Photographs of the uses, the alterations, the changes. Of course, the flea market is better situated than anyone to know how it is using its property. It is fair to charge the flea market with how its property is being used. So you have the words plus the photos of the alterations, the changes. But there's still
your friend. your friend's argument is, so I think that could be a reasonable interpretation perhaps, but your friend's argument is the requirement is that there must be a description of the violation. And you're not asserting that every single thing in the site plan was a violation of the ordinances. You're not asserting that every single thing you could see in those pictures was a violation of the ordinances. So the argument your friend is making is there is no description of the violations. You just handed me a bunch of illustrations of where there are some violations somewhere, but then never described what those violations are. And so I guess my question to you is, what about that reading of the requirement is unreasonable? Because certainly if the ordinance had said, if you're in violation of a site plan, we can provide you with notice that you're in violation of the site plan. And that may still raise due process concerns, but certainly it wouldn't be in conflict with the text of the ordinance. But that's just not what it says. It says you'll get a description of the violation. So can you see that it seems at least to be a reasonable reading, the one your friend has articulated here?
It is a reasonable reading that a description of the violation is required. But what is unreasonable, what the city disagrees with, there's no description in this case. Because in addition to the words, you don't conform with your site plan, the nonconformity is some change you made, and the pictures, there's also a site map. The site map that the flea market submitted to the city for approval. Again, it's reasonable to charge the flea market with the knowledge of its own site plan. So taking all those things together, to know what the violation is, you look at the site plan that shows what is permitted, you compare it to the pictures. If there's something in that picture that is not on the site plan, that is the alteration, that is the change, that is the violation. If there's something in that picture that is not where it's supposed to be, that is the change, that is the alteration, that is the violation. For example, I don't know much about engineering drawings and site plans, but I could look on that site plan and see what is permitted is there's one large rectangular shaped building. So when I look into a photo and I see a second smaller building, I know that second building is not approved. Justice Dietz, that is a clear description of the violation. But there's more, because in addition to the words, the pictures, and the site plan, also included with the notice of violation is the ordinance that says any changes that are not approved is a violation. So all of those things together, Justice Dietz, is the description of the violation.
The Court of Appeals, in its reasoning, mentioned that the notice provided contact information with the option to reach out to the city's staff to inquire about the violation. What's your position on that? Because it seems to me that the statutory requirement and the ordinance requirement is for written notice. So I have a hard time getting to where the Court of Appeals got to and saying, well, a phone number will, to the extent there's still a deficient notice, the phone number was a cure. It seems to me the written notice has to be sufficient to comply with the statute and to comply with the ordinance.
Justice Allen, my recollection of the majority opinion, the Court of Appeals opinion in this case, is it mentioned that informal conversation as a factor to consider when determining whether there was procedural due process in this case. The majority opinion cites to the Lipinski case, and in that case, a notice of violation was issued. The property owner had a meeting with a representative of the town to clarify what the violation was. So as I understand the majority opinion, that was just a factor in the due process analysis. But I agree with you that the notice should come first.
In other words, it seems to me that the fact that you give a contact number can't, is no substitute for a notice that includes an adequate description. Would you agree with that?
I agree, it is not a substitute for a written notice. It is a factor that this court can consider when the representative of the flea market, Mr. Robert Perry, testified. He had a phone call with a compliance officer, and they talked about the violation. I believe that is a factor you consider, but no, it does not replace written notice.
And so to follow up with that, does that then bring us into the realm of actual notice?
Is your question about the conversation or the written notice?
No, about the
Justice
conversation. The conversation, since it's not written notice and it's some kind of factor, does that bring us into the realm of actual notice? And if that's true, would that be enough if for some reason we saw that the written notice was inadequate?
Actual notice by itself is not sufficient where there is a requirement to provide written notice. But there was written notice in this case.
Should we be concerned with the testimony of Mr. Robertson when asked about specific violations? He said, there were several different violations, I'm quoting, several different improvements to the property without a site plan, and then says, we don't want to issue something that says, hey, fix this, this, and this, when there was a whole lot of things that were improved on the site. So if we went through and listed it, he could fix those things and not fix the others. Why isn't it the duty of the inspector and the planning department to specify what things needed to be fixed?
Justice Newby, no, I don't think you should be concerned about that testimony. I think that testimony reflects nothing but the frustration of the history of this property, which is listed in the staff report that is in the record. There's just a history of the flea market expanding its use in a way that's not part of its approved site plan. They get a notice of violation and they submit a new site plan to accommodate the new use. So because of that history, I believe the compliance officer, Mr. Landis, just wanted to issue a notice of violation that captured the many changes at the site that were not approved. And so the language, you're not in compliance with a site plan, the language that the problem is the alteration, that captured everything. But when you look at all the parts of the notice of violation together, again, the words, the site plan, the pictures, the ordinance, when all those things, when you consider all those circumstances, there was a specific notice of violation that provided adequate notice. And there's evidence in the record that the notice was sufficient. The document that the flea market filed to appeal the notice of violation to the Board of Adjustment, nowhere in that document does the flea market allege that they don't know what the violations are. On the contrary, they can see their violations. The stated reason for their appeal is we thought the violations would not be enforced because it's not being enforced against others. So based on that document, at least when the flea market filed his appeal, there was no question about the sufficiency of notice. Ironically, it is the city who had no notice that the flea market was claiming an insufficiency of notice of the violation until Mr. Perry was asked a leading question at the Board of Adjustment hearing. And that's the first time insufficiency of notice came up. So The notice of violation in this case met the constitutional procedure due process standard. It also met the standard of the city's zoning ordinance, which has 5 components: identification of the violation, failure to comply with the site plan, changing the making alterations, the changes, those are the violations. 2, the location of the violation. There's no question about the violation was at the flea market. The address is on the notice of violation. 3, how to cure the violation. The notice of violation says you can cure it by removing the alterations. 4, the potential penalties. The notice of violation explains what those penalties are, fines, and even a misdemeanor. And 5, what the flea market's appellate rights are. Those were explained, and indeed, the flea market took advantage of its appellate rights in this case by appealing to the Board of Adjustment. So the notice of violation issued in this case satisfied the requirements of the city's zoning ordinance and constitutional procedural due process. Justice Allen, you mentioned the Court of Appeals opinion in this case, and I want to take a moment to set the record straight about some of the analysis in the dissenting opinion in that case.
Well, and before you move to the dissent, I have a question because you have touched on the remedies or the result that was noticed, that you allege was noticed, but I'm puzzling over the language in the majority opinion that says ordered to bring the property into full compliance with a site plan approved by the Durham City County Planning Department within 36 months. The Court of Appeals opinion applauds this as an extension of time, but when I read it literally where it says with a site plan, one interpretation is that there would be a new site plan that would be approved within 36 months, and this court is so ordering it. Is that an appropriate order, or am I misconstruing what that language means? It doesn't say into full compliance with the site plan. It just says a site plan approved by Durham County. That to me leads me to think that the trial court is saying you've got 36 months, but we need a new site plan here. What does that language really mean in your view?
Justice Barringer, the transcript of the Superior Court hearing makes clear what that language means. And the transcript is part of the record. After Judge Hardin, the trial judge, had decided the case against the flea market, it asked the flea market, what do you want to do? And Ms. Chelsea Edwards, former attorney for the flea market, said, we will submit a new site plan. But she wanted more time than the judge was willing to give her. And Judge Hardin seemed to get a bit frustrated. He said, you know what, I'm going to give you the option. So his order doesn't say new site plan. It doesn't say comply with the existing site plan. It says what you're on a site plan. So they can comply either way. The free use of property includes the freedom to submit a new site plan if that's the choice the flea market wants to make. But it can also simply come to compliance with its existing approved site plan. That is what that language means, and that's how it came to be. Justice Barrett, that's a nice segue into my first point about the dissenting opinion, because the dissent is wrong when it writes that the trial court abused its discretion by issuing an order that exceeded its statutory authority. According to the dissent, it didn't have the authority to say flea market submit a new site plan. And the language you just recited, that's not what the trial judge did. They don't have to issue a new site plan. They can't comply with the existing site plan. So that's one of the problems with the dissent. And that problem is important because that's part of the reason it found a due process violation. A second problem with the dissent is that the dissent writes that the flea market was denied the opportunity to present its evidence about the supposed selective enforcement of the zoning ordinance. But that simply didn't happen. Again, the transcript is part of the record. If you look at the transcript, you will see a representative of the flea market, Mr. Robert Perry, was asked, do you have any evidence to support this allegation of selective enforcement, discrimination? And Mr. Perry testified. He testified about a store that he believed had zoning violations. He also testified about a second flea market who, according to him, is being allowed to operate without any regulations. So that was the evidence that he presented on that defense. He was not barred from doing that. The dissent simply has the record wrong on that point. The dissent is wrong on the third point when it writes that there was no opportunity to participate in an informal process that some of us have talked about this morning. Again, the transcript of the Board of Adjustment hearing shows that Robert Perry testified about the telephone conversation that he had with a compliance officer. It's important to set the record straight on that point because the dissent writes that is why this case is different from the Lipinski case where there was that informal opportunity. So the dissent's right. He didn't have that, the flea market didn't have that informal opportunity in this case. But the dissent simply has the record wrong on that point. The flea market did have that opportunity. The dissent, when it rules that there was a procedural due process violation, when it rules that the trial court exceeded its statutory authority, it is based on incorrect statements of the record. I want to address some of the arguments that the flea market has made. Like the dissent, the flea market in its reply brief, they make an argument that the city convinced the trial court and the Court of Appeals to expand the city's regulatory power by requiring the flea market to submit a new site plan. I've already talked to Justice Barringer about that. That is not what the trial court did. That is not what the order says. But even if that is what the order said, the flea market can't raise that argument for the first time in its reply brief. So that issue is not properly before this court. But even if it were properly before this court, flea market couldn't be heard to complain about it because it's an error that they invited. I've already explained about the conversation that Attorney Chelsea Edwards had with the trial judge, Judge Harding, where Judge Harding asked, what does the flea market want to do? And she answered, we will submit a new site plan. Not only is the request made there, but it's also made in the petition for discretionary review that the flea market filed to appeal from the Board of Adjustment to the Superior Court. In the record on page 12, at paragraph 3, their prayer for relief says they grant the petitioner an extended period of time to amend the previous site plan substituted to comply with the city's regulations. So at least twice they asked to submit a new site plan. So even if the trial judge had committed an error by giving them what they asked for, it would be an invited error that the flea market could not be heard to complain about. My last point I want to address is the invitation that the flea market extends to this court to draft a notice standard. That would be improper. This court is not a super planning board. And this court recognized in its decision of School Dev East LLC versus the town of Wake Forest, zoning ordinances are legislation. In that case, when you talked about the canon of construction that my friend on the other side mentioned, that is a statutory canon of construction. And under our system of government, it is for the legislature, in this case, local legislature, cities like Durham and others, to draft legislation. That is not a function of the judicial branch. So this court should decline that invitation. The notice of violation in this case, when you consider all its parts together, gave specific notice of what the violation is, how it can be cured. It complied with the city zoning ordinance. It complied with constitutional procedural due process. And for those reasons, the city respectfully asks that this court affirm the majority opinion of the Court of Appeals. Unless there are questions for me, I'll sit down.
Thank you, counsel. Rebuttal.
Thank you, Your Honor. I want to start by addressing this site plan issue that my friend just raised in his memorandum of additional authorities. Just to be clear, we aren't raising this as an independent issue. I mentioned it at the end of our reply brief just as a point of saying we were forced to submit a new site plan because the option is supposed to be go cure the violation. No one will tell us what the violation is. So there is no other option for a landowner in this position except to go through the expense and the hassle of submitting a new site plan because there's no ability to cure. So I raise this argument only in service of our due process argument. I do want to point out that I disagree with my friend on the other side. If you were to look at the Superior Court transcript, the idea that we invited a site plan, we had just lost at the hearing, and it was like negotiating the form of the order. It was certainly never the market's argument that it wanted to have to be ordered to submit a new site plan. To my friend's argument about, well, the property owner's in the best position to know, in what ways his property is out of compliance with the law. I mean, you could say that anytime the government comes after someone. You could say, well, criminal defendant, it's really, you know what you did. I don't need to give you notice in the indictment, but we would never think that complies with due process. But the due process clause applies just as equally in both of those situations. Now, I also heard my friend on the other side to try to explain the photographs today. He says, well, I looked at the photographs and compared it to the site plan, and I could see a building that wasn't there. Well, if it's really that simple, then why didn't the city just write that in the notice? You have a building that's not there. Here's a picture of it. It sort of boggles the mind why, if it were that, I don't believe that. I'm not sure really what the city's actual violations are. They still didn't say them today in the oral argument. I didn't think it was very clear from their brief. But if it was really that simple, they could have just said it. We're not asking for some Herculean interpretation and burden to be put on the city through the ordinance or through the statute or through the application of due process.
Can I ask you a question about how far you want this court to go, at least in the reply brief? You talk about a photo can never suffice to satisfy 160D 404. So imagine a different scenario where the only issue is that the site plan, and let's say it's a more readable site plan than this one, because I've seen more readable ones, makes clear that there needs to be an unobstructed handicap parking spot right by the entrance. And, there's words on here, but I can't read them. But it says that, and it points to that. And Durham submits the site plan, puts a red circle around that handicap spot. Then Durham also provides a picture, more legible or readable than these, that has a picture of that handicap spot circled in the site plan with a small shed on it, or a porta potty, I don't know, something, and then puts a red X through it. It just seems to me that one, this is the written notice required by 404. The description required under the ordinance, that we don't need to get into micromanaging that. I mean, it may not be best practice to use pictures and red circles and red X's, but do we really need to micromanage to that level?
I would agree with you that that would be a very difficult due process argument to raise. I would worry that if there's still not some more words, at least saying no porta potties here, you need to remove the porta potty, something like that, then I'm not sure that that's going to meet the written notice requirement. I agree that that's a lot more difficult case than this one. I don't think this court needs to write an opinion that says photographs never. I think the court could easily write clearly the photographs in this case were inadequate, and maybe hold that, if they were self-explanatory, you could maybe the court would interpret writing as, those symbols that you're putting, adding to the circling and the marking through on the site plan and plus the photographs. Maybe there's a world in which that is sufficient. I still think that's a close call as to whether that meets the written requirement in the ordinance and the statute. Of course, that's miles away from this one. I have tried to present the court with ways that the court could write a broad opinion, a narrow opinion. It could be just about the ordinance. It could be just about the statute. It could be about due process. We're happy to win any of those ways. So I don't mean to tell this court how to write its opinion, but I do think that there could be some difficulties in that example, and I think that each of the three bodies of law might not shake out exactly the same in that example. I hope that answers your question. I want to address also this informal phone call. As members of the court pointed out, that really doesn't satisfy at all the written notice requirement. And I think that there's a policy decision here that the General Assembly and the city through its ordinance has made by requiring this the writing requirement. It should be clear to everyone going into this hearing what the violations are, because if we're relying on oral communications through some phone call, well, the Board of Adjustment, they're not party to that phone call. So how are they supposed to know, they're the adjudicator, how are they supposed to know what violations they're supposed to be looking for? So I think it would be very bad policy if we said that's how you go get your notice, is through this informal communication that's off the record. That's not what the General Assembly intended. They wouldn't have said written notice of violation if they meant, oral notices are sort of okay too. And so that really let the city, by doing that, even though they say that there was this phone call, that the transcript, I believe, is not very clear about what exactly happened on this phone call, it let the city make up its accusations as it went along. That transcript from the Board of Adjustment hearing is a mess. The transcript from the Superior Court hearing, it's a mess, because the city, through neither of those hearings, will be clear about what the violations are. And so if they were relying on some oral conversation, that just shows that's not how this process is supposed to work. My friend has also mentioned that maybe there's some defect in the appeal notice that was initially filed that sort of triggers the Board of Adjustment hearing. I want to be clear, I don't think there was any defect. We have been really clear about arguing due process all along. We certainly argued due process at the Board of Adjustment hearing. It's also not within the scope of none of the opinions addressed at the Court of Appeals. It's not within the scope of the issues presented to this court. So I think that that should be set aside. So if there are no other questions, I would respectfully ask that the judgment of the Court of Appeals be reversed, in this case be remanded with instructions that the matter be dismissed. Thank you.
Thank you, counsel. Mark.